Dear David Hecht, the Copyright Office refused registration for this work on December 19th, 2018, which is kind of weird because that's actually when we were talking about these lawsuits last, and when I did an interview with Bloomberg Law, I believe, and I think I said that these plaintiffs had an uphill battle because the dance moves have to reach a level of choreography, not just an individual dance move, but rather a string, a repeatable pattern. I said it would have to be more than just an up, down, left, right, BA start kind of thing. It would have to be an actual longer choreography that can be written, described, and repeated. And that's what they're saying here. All right, what have we got going on here? We got a mess of wires and a mess of cameras. I really want to bring you several of these great stories. I am away from the United States again. I am in Scotland visiting with Ms. Cayley for Valentine's Day, it's a wonderful trip, and I'm really floored, blessed by your support that I'm able to do this. So thank you very, very much. So what's happening with the Fortnite dances? All right, so a couple days ago, Epic Games filed a motion to dismiss, and usually the motion to dismiss itself isn't that terribly interesting. It's the memorandum in support of it that makes it worthwhile. They are going to claim that plaintiff cannot state a claim for copyright infringement because their dance step is not protected by copyright. It is not anything more than a mere unprotectable idea. And then they're going to cite a little bit about trademark and all that. We're not going to really cover the trademark too much because I don't really see that claim. This is not going to be a read-through of the lawsuit. This is going to be more of a short, poignant thing pointing out what has happened. So let's scroll past all of their points of authority and go straight to their introduction. Plaintiff's lawsuit is fundamentally at odds with free speech principles as it attempts to oppose liability, thereby chilling creative expression by claiming rights that do not exist under law. No one can own a dance step. Copyright law is clear that individual dance steps and simple dance routines are not protected by copyright, but rather are building blocks of free expression, which are in the public domain for choreographers, dancers, the general public to use, perform, and enjoy. So first, they're going to claim that the infringement claims should be dismissed because the plaintiff cannot establish substantial similarity in his work. That's the basic premise of a copyright infringement lawsuit, is either that there was actual copying or that something you created is so substantially similar to the original work. And as long as you had access to the original work, then you can in fact be liable for copyright infringement, even if you didn't directly copy something. It can even be another work that you created and appears to be substantially similar. Their first argument is that it's not copyright infringement because it's not substantially similar. And then there are some other non-copyright claims. They cite California's anti-SLAPP statute. An anti-SLAPP statute, SLAPP is strategic lawsuits against public participation. So it's basically like filing a frivolous defamation lawsuit or something similar in order to chill the defendant's ability to speak for themselves. The defendant in this case would be Epic. Let's see. All of the non-copyright claims involve the same dance step. Plaintiff's right to publicity is barred by the First Amendment under the transformative use test. Fortnite has distinctive and expressive content beyond alleged use of the step. And then they cite Rogers v. Grimaldi, that the swipe it emote and the dance move and all that are not protectable expression. So let's see what they're basing that on. I'm going to skip ahead here to their Exhibit H, where they cite the United States Copyright Office e-file correspondence. This is regarding, I believe, the 2 Millie dance moves. The Millie Rock, I think he called it. Let's take a look at this letter on December 19th, 2018. So that was 2 months ago. And it says, Dear David Hecht, regarding the Millie Rock dance, we have received an application to register a claim of copyright in choreography for the work entitled Millie Rock Dance. For the reasons discussed below, the office refuses registration of this claim. As an initial matter, we note that on October 10th, 2018, under service request number yada yada, the office received a related choreographic claim, train, by the same author and claimant named on the application for Millie Rock Dance for a work entitled 2 Millie Rock. Expedited handling was requested for 2 Millie Rock on the basis of prospective litigation. The deposit submitted with the October 10th application consists of a short video of approximately 24 children imitating a simple routine or social dance move being demonstrated by 3 people at the front of the room. Notably, the video appears to be a demonstration of a particular social dance move popularly known as the Millie Rock. The office expeditiously refused registration for 2 Millie Rock in a letter dated October 16th, 2018. That means they knew about the pitfalls with this all the way back in October. The refusal letter explained that the work did not constitute a choreographic work, but rather represented a simple dance routine. As the legislative history of the 1976 Copyright Act states, choreography does not include social dance steps or simple routines. The current application for Millie Rock Dance, submitted on December 4th now, a second application, under service request, a different number, was sent with a different deposit. Let me just verify. Yeah, different number, was sent with a different deposit. A video of an individual on top of the roof of a parked car performing simple dance movements in an improvisational manner, including the 2 Millie Rock Dance that had previously been refused by the office on October 16th, 2018. I think we reviewed that video a little bit to try and see if we could put together whether this was truly choreography or unprotectable dance moves. While the video submitted for registration with the December 4th application is different and longer than the video submitted with the October 10th application, the office finds that this longer routine of improvisational dance movements does not constitute a work of choreography. The movements represented in the video deposited for Millie Rock Dance depict a simple routine made up of social dance steps and do not represent an integrated, coherent, and expressive compositional whole, and is thus not eligible for copyright registration. Now, one of the requirements for relief under the Copyright Act is that you do register your copyrighted work before you can complete a lawsuit. Now, there's a circuit split, and about half of the 13 appellate circuits say that you don't need to have that registration completed and fully registered with the Copyright Office, but rather you only have to have made the application in order to start the lawsuit. So I need to look up which of our circuits we're in here, but really either way, whether we're in one circuit split or the other side of the circuit split, there likely isn't a remedy since there's no copyright underlying the claim. For copyright purposes, choreography is the composition and arrangement of a related series of dance movements and patterns organized into a integrated, coherent, and expressive whole. This is part of what I was quoting when I did the Bloomberg Law interview. Choreographic works are typically performed by skilled dancers for an audience. By contrast, social dances, such as ballroom dances, line dances, and similar movements, are not created for professional dancers. They are instead intended to be performed by the general public for their own enjoyment. For more information, see the Compendium 3rd, Section 805, which I guess is the Copyright Compendium. The office finds that the video submitted with the December 4th application depicting a social dance move known as the Millie Rock does not support a claim in a choreographic work. For the foregoing reasons, it must be refused. In accordance with U.S. copyright practice, we will retain the application, deposit, and non-refundable application fee, about $35, I believe that is these days. So this letter is for your information only. No response is necessary. Ed Bellafiore, Copyright Examiner, Performing Arts, Office of Registration Policy and Practice, United States Copyright Office. For more information, you can go to www.copyright.gov. So this is the appropriate outcome. Now, the case isn't dismissed yet. The Epic Games has filed their motion to dismiss, and we now have to wait for a response from the opposing side. This was only filed on February 11th, so that's 4 days ago. Usually, most courts have a 14-day response period, so 2 milli has a chance to respond in a little less than 2 weeks, and then Epic usually gets one more chance to respond on the papers, and then the judge usually either holds an oral argument hearing or rules on the motion to dismiss. Sometimes within a few weeks, sometimes it takes a few months. We saw the summary judgment motions from the H3H3 Productions case take several months to be completed and then suddenly drop one day when no one was expecting it. So that's what's going on there. 2 milli doesn't appear to have received a successful copyright registration. Not only that, it's been actively denied now, and Epic Games is citing that in their lawsuit. I'm assuming a very similar thing is happening with the Carlton dance, which I saw a headline was also denied under similar grounds. So that's how choreography and dance moves work. As much as you might want dance moves individually to be copyright protected, can you imagine the result? It would be untenable. Anybody could make a move. Look, I'm making my one arm up and then doing this back and forth. Now all of a sudden I own it and nobody else can do it. No, that's not how that works. That would just be absolutely untenable. Then we'd have a whole court case between somebody and me, and then somebody would hire a copyright history expert to try and say, no, there was somebody who did this back in 1959, and then somebody's going to come forward and say, no, they didn't do it, then they did it in 1949, no, 79, no, the dates are wrong, when is it? No, this is way too complicated for something so simple. So that's why this doesn't get copyright protection. We want it to be an entire written out choreography that can be repeated and performed the same way every time. Like they said here, it has to be patterns and movements as part of a coherent whole, and a little bit more. So thank you for joining me. I am Leonard French, your favorite copyright attorney, and thank you to our $50 per month Patreon sponsors, Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Jacob Papenfuss. Really appreciate all your support. Also, thank you to all of our $5 plus supporters that will be scrolling on the screen right now, and all of our other supporters on Patreon, Twitch. I don't even remember where everybody comes from these days. It's an awesome experience that we have. I'm going to keep this short. Love you all. I'm Leonard French. Have a great weekend. Bye.
Come on, stop. She's hogging both balls. You got to see this. She's hogging a volleyball and a tennis ball, and she won't let anybody have either one. If I try to take one, she will hog both. If I try to take one, she's guarding both balls, and now she'll let us have this one. This was given on permission, which is why I'm giving it straight to him, because he's a jerk.